economy and helping not only India, but economies worldwide operate during these very difficult times. In the backdrop here, India, I think it's fair to say across the board, is developing its regulatory regime around e-commerce. And one of the areas that's not well understood and is an emerging area of regulation within India is the consumer protection regulations. And while consumer protection is a sort of broad-based area of regulation, some of the initial activities clearly are targeted on protecting consumers in the e-commerce environment. And that's why today's conversation is so important. As India develops this new strand of regulation, I think back to how India developed competition regulation within the last decade. They passed a new law, they ramped up a new regulator, started with some fits and starts, but slowly developed an independent regulation and a series of jurisdiction around competition. I fully expect in the years to come this to occur in the consumer affairs space as well. Obviously, e-commerce is going to be one of those failing sectors that will help define and drive consumer regulation kind of going forward. So with that, we're really pleased today to have our guests at Nishit Desai Associates lead a conversation. I'm going to hand it over to them. Generally speaking, we're going to have an introduction of where we are, what's going on, what we need to think about. And then in the latter half of this conversation, we want to have a discussion. So for those members on the call, please feel free to either raise your hand, we'll call on you, or drop a comment into Teams and we'll capture that question going forward. With that, I'm going to hand over the microphone to our Nishit Desai Associates.
Thank you so much, Jay, and thank you for setting the tone of this event. Just a quick introduction from our team. We are three of us. This is me, Huzafa Tawawala. I head the international commercial law practice and a senior member of the digital e-commerce team. With me, I have Gauri Gokhale. She heads the TMT practice of the firm and is one of the senior most members of Nishit Desai Associates. Along with both of us, we also have a tax colleague come in to give some light from an international cross-border perspective. So we have Maya. He's also done his LLM from the US, and he's an expert, and he heads the international digital tax team for the firm. So I think, we three are going to strive and make this extremely interesting for everybody on this call. So let's begin without further ado. And why don't I hand it over to Gauri, who will kind of do some context setting, along with introductions of this topic. Over to you, Gauri.
Thanks, Huzafa. I think most of the participants here must be familiar with all the developments that we have seen in last several years in the e-commerce space, right from the discussion around e-commerce policy and what should or should not go within that policy. The second development is, of course, multiple laws which were thus far being made applicable to the brick and mortar type of businesses are now getting made applicable to the online business, and we saw some of the changes, for example, under the legal metrology law and the food law, etc. And now, more recently, of course, we have the Consumer Protection Act. Along with this, we also need to, tie up the discussion about the Consumer Protection Act also to the FDI policy, which is the Foreign Direct Investment Policy, which is now incorporated in the non-debt rules under the Foreign Exchange Management Act. And I'll explain why it is relevant to look at it together. So just to take a step back and see what we had when we talk about consumer protection law thus far was a 1986 law, which essentially dealt with the consumer protection. Overall, it didn't really distinguish between online or offline space. So technically, it also applied to the online space. However, the need was felt to further enhance the applicability to the online space with specific provisions. So when the 2019 Act was brought in, there were several other changes. For example, bringing in the product liability issue, or for example, bringing in liability in terms of endorsers, the brand endorsers, some additional, sort of do's and don'ts for them. So there were several other changes brought in. But along with that, we also have a specific provision under the law which allows the government to come out with the rules that are required to protect the consumer's rights. And for the first time, the consumer rights have been also defined under the Act, which includes the right to information, right to be protected against hazardous product, right to be heard, right for redressal, etc. So for protection of these consumer rights as well, the government was allowed to come out with specific rules for e-commerce entities and what we call as a delegated legislation. So that is something when the 2019 Act was made applicable end of July, that is 20th July, within a couple of days, that is on 23rd July, the consumer protection rules also were brought into effect. And when I say brought into effect, they have been made applicable immediately as on that date, end of end of July, and there has not been given any specific timeline for the companies to comply, right? And this becomes important because that means those companies who do not have the requirements that are required under that law today, as we speak, may be held to be in non-compliance, right? So that is why I thought I'll clarify that they are effective immediately. Now, when we talk about consumer protection overall, I think the main issues, and as we get into deeper, we will discuss about that as well. But the main issue that has been brought into by the consumer protection rules is the localization requirement. That means setting up of some Indian operations, and we will get into the nitty-gritties, of that. But because of that, we also need to, in parallel, look at the non-debt rules when it comes to foreign direct investment policy. And some of you may already be familiar with it, but just a couple of quick takeaways along with some of the recent developments. As we know, for a single brand retail trading, you could have an e-commerce business so long as you either today have a brick and mortar stores that cater to the retail trading in India for single brand, or in next couple of years you need to have that in place. That is the physical outlets in addition to the e-commerce outlets. When it comes to multi-brand retail trading, of course, that is not something that is permitted. From an e-commerce perspective, 51% FDI is allowed in the multi-brand retail trading entities, but they cannot carry out the e-commerce activity. Why does it become relevant? Is because the moment we say under the Consumer Protection Act, you need to have a local entity, that time we need to examine what is our business model when we talk about the local entity. And that is why, whether under the consumer protection rules or for the FDI policy, the two main categorization of the nature of entities has been inventory-based e-commerce and the marketplace e-commerce, right? Marketplace, as you know, it basically is a tech platform. Buyers and sellers come together on that tech platform, and the marketplace is facilitating that transaction between the buyers and sellers. So you will find the definitions are somewhat similar under the FDI policy as well as the e-commerce rules that have come in. And the second category is inventory-based model. That means you own the inventory of goods and services as an e-commerce entity, and you yourself are directly selling those goods and services to the end consumer, right? So with these two categorization, and that there could be many more types of e-commerce entities, but these are the two main categorizations that have been identified, and the laws and the rules become applicable depending upon who you are, whether you are a marketplace or inventory, and the do's and don'ts apply accordingly. So I think that's a quick snapshot on where we stand, and as we get along into the rules, we will discuss in more depth as to what really means by compliance of the e-commerce rules.
Thank you so much, Gauri. I think the tone has been perfectly set. I think Jay, you wanted to make a quick comment?
No, I think the key takeaway, and correct me if I'm wrong, is that we're continuing with the sort of marketplace model versus the inventory model, and so there's going to be slightly or maybe significantly different requirements in each of those. Is that a fair assessment?
It is, and which is what we are going to talk about, is where does the applicability and where is the impact felt, right?
Right.
Which was exactly what I was actually going to pick on.
Okay,
So,
wonderful.
Excellent. So I think, Jay has actually raised a very valid point, and which is what I'm going to elaborate on. That how does it create an impact? Yes, we all know what marketplace is, we all know what inventory is, but these are commerce laws, these are e-commerce laws. How, and from a consumer protection act, where has this become so impactful? Because as Gauri said, these new rules which have been introduced are essentially called the consumer e-commerce rules. Now, essentially, e-commerce rules are meant, or the consumer protection legislations are meant from a consumer protection perspective. They don't go and legislate how e-commerce businesses function. But this has what has changed under this particular enactment, which has recently introduced. So first and foremost, under the guise or under the umbrella of the Consumer Protection Act, these rules were released. The applicability was very straightforward. It said that it applies to buying and selling of goods or digital products over an electronic or digital platform or a digital network, which is simple. Essentially something, you're buying and selling goods and services or digital product online. Essentially, the Consumer Protection Act was limited to the jurisdiction of India, which meant that it applied to the territory of India and activities which were conducted within the territory of India. But with technology coming in and which is actually changing in terms of how businesses work, these e-commerce rules went one step ahead. They said that these rules will apply to electronic online commerce. It will apply in India, but this is where the big needle mover was. This was where the big impact was. It also said that it will apply to a foreign company which is systematically offering goods or services to consumers in India. I will repeat this. These rules went beyond the territory of India, and they said that it will apply to a foreign e-commerce entity which is systematically offering goods or services to consumers in India. So there are two important parts which need to be touched upon. One, there has to be a foreign e-commerce entity which is in the business of e-commerce. Second, it is systematically offering these goods or services to consumers in India. Please note they use the word systematically offering. It's not systematically selling or Indian consumers making purchases, just the activity of making targeted or continuous offerings digitally to Indian consumers would trigger the rules. So there is no threshold in terms of purchases. Simple offering actually triggers the rules. And this has, been under the spotlight since the day it has been released, as Gauri said, a few months ago. And one of the biggest questions is that whether the Indian consumer forum or the consumer legislative body has gone beyond the realms of its jurisdiction, whereby since the entire act was only limited to India, can the rules go beyond the act and have extraterritorial jurisdiction? So this was one of the single most important touch points, whereby these particular rules extended the applicability of compliances to foreign companies as well, which are doing business in India. And as we discuss, we will also get into what are these sort of compliances, and is there something which is actually path moving when it comes from a India US perspective. But I'll take a pause, Gauri. If you want to chime in here on something, please feel free.
Sure. So I think this aspect of localization that Josefa has mentioned, that has become very critical, and let me take that aspect immediately. So if we really see, there are three elements coming out of the new rules. They are, I mean, honestly, only 8 rules if you really see, but 3 primary elements. One is the localization, as we mentioned. Second one is transparency. And the third one is the consumer redressal, right? In terms of the grievance redressal mechanism that needs to be put in place by the e-commerce entities. Now let me deal with the first aspect, which is the localization. And the localization, they're looking at three separate kind of verticals. So they say that the e-commerce entity needs to be an entity which is a company in India, right? Under the either of the Companies Act. They don't unfortunately recognize sole proprietorship, partnership, LLPs, and we are aware that quite a few foreign companies have established for various reasons LLPs in India, right? So unfortunately, they don't recognize LLP as one of the entities. The second thing that gets triggered, what they call is as a Section 242 company. That means under the Companies Act, there is a recognition that if a foreign entity is offering services in India, goods or services in India by an online mechanism, then there is a identification of that entity also as a foreign entity. I'll try to keep it as simple as possible. Now the question is that here they don't say in the rules, the e-commerce rules, they don't say that it has to be an entity registered as a 242 company in India. They simply say it will have to be a foreign company covered under clause 242. So the question is that, do I satisfy the requirement of this localization by simply being that entity, which is a foreign entity, supplying the goods and services through that channel? But I don't believe we can really stop here, because the moment I say that I am a company falling under 242, that means under the Companies Act, there is a trigger of registering yourself within India. And what does it mean by registration? And unfortunately, this is something we have tried to, check with the Ministry of, the Company Affairs. We have not been able to get a complete clarification. So suppose you have a foreign entity which does have this kind of, operation systematically offering in India. However, they don't have a local presence, right? Can they still go and register under the Companies Act? At least currently, they don't provide for that kind of a that kind of a procedure. It seems to us that means you need to have either a branch office or a LO in India, that is a liaison office in India, under under the relevant, after obtaining relevant RBI approval. And unfortunately, as some of you may be aware, the LO and the BO can carry out only limited activities in India, right? So this particular avenue, depending upon how you are structured outside India, we will need to examine further depending on facts and circumstances of each company as to how and to what extent can we satisfy this requirement. And the third option they have given is slightly, there appears to be some drafting error. So it is the way they have articulated, it could be an Indian company, but the business, e-commerce business, could be run by their offshore branch office or a liaison office. That is one possibility of interpretation. Or the second possibility of interpretation is that the foreign e-commerce entity has a branch or a liaison office in India, and that Indian branch office or liaison office is running the e-commerce business. Now, considering, let's this is one aspect as to the entity identification. But the next question arises is whether what is that entity in India required to do, right? So when we talk about what is that entity in India required to do, is if you go back to the definition of e-commerce entity, that entity should be the entity owning, operating, or managing the digital platform, right? So suppose some of you have a global platform and it is not a country specific platform. Then you decide to say from a compliance perspective, you decide to have a local entity in place. The question that arises is that how, when we talk about ownership of the platform, which is your global platform, can you really transfer that limited ownership for India purpose to the Indian entity? Or are we going to say that, okay, the ownership may remain outside India of the platform, but the operation and management of the platform will be carried out in India? And if so, what are the elements of that entire business that will be carried out in India, right? So, as we get into the compliance, for example, nodal officer to be in India, grievance officer required, etc. So when you get into further details, again, depending upon how your platform is structured, what activities are being carried out, we will need to examine how and to what extent can we say it is the now the local entity is carrying out that e-commerce business. It cannot be that the foreign entity continues to be carry out that e-commerce business and Indian entity is simply having a nodal officer. That also may not work the way currently rules are drafted, right? So that is why you need to break down your activities of the platform and figure out what activities can be shifted to the Indian entity to satisfy the compliances. Of course, this is if you are a 242 entity, then that scenario will be different, right? So I thought I'll just clarify these nuances, which unfortunately even the regulators, to our mind, regulators also have not thought through completely, because each business model will be different, and that is why we need further deliberation in my mind in similar platforms and make recommendations to the government that some of these issues will have to be clarified.
No, absolutely. Thank you so much, Gauri. So just to kind of summarize it, in a nutshell, from a process perspective for all our, participants. Yeah, go ahead, Jay. I think Jay has a question.
Yeah, we have a question from the audience. I wanted to see if Ashish from eBay has a question about. Ashish, do you want to come online, or would you like me to ask you?
Yeah,
The question is.
Either way will work, Jay. I mean, my question is that I heard Gauri clarifying the difference of jurisdiction. I mean, the act has a limited jurisdiction, whereas rules went ahead and invoke extraterritorial jurisdiction. So my question was that if since rules has been formed under the act, so will it not be considered that rules are having the ultra virus?
no,
Yeah,
that's
so
a.
let me.
Yeah, go ahead,
Yeah.
Gauri.
So let me take that question and I'll answer in two ways, right? Let's park for ultravirus for the few seconds. But in our view, the rules go even beyond the act in overall scheme of things, right? Because if you really see the reason for which the rules could have come out versus what rules are trying to do itself, from a delegated legislation perspective, even that is going beyond beyond the scope. So one is the extraterritoriality, but the second one is even the scope also could be challenged to say that it is going beyond what is required to be done by section 94. And the third element is also the fact that there are several compliances that have been imposed under the rules, which are imposed only on the e-commerce platforms, right? For example, the days within which you need to resolve consumer complaint, or what terms and conditions you should have for refund and exchange, whatnot. So all these conditions, why are they imposed only on the e-commerce platforms and not on the brick and mortar, right? So even from article 14, which is constitutionality of equality, even from that perspective they are ultra virus. So you have a constitutional challenge available, and in our mind the extraterritoriality challenge available, as well as the ultra virus challenge available, right? So in all these three respects, in our mind, there is a challenge possible for these rules. Does that answer your question?
Yeah, to the extent, Gauri, thanks for clarifying. I think that equality and level playing field is important, and that concept has been brought time and again in press note 2 and press note 3 of e-commerce. I
Yeah.
don't know why the regulators missed here, bringing that equality between brick and mortar, I mean the retailers or offline retailers versus e-commerce.
Right.
Yeah,
Great.
absolutely.
There's another question from Natasha. Do you want to jump online and ask your question? And we have one more from the audience as well.
Yeah, thanks. Can you hear me, Jack?
Yes.
Yeah, thanks. The chat box somehow is disabled for me, so I'll quickly ask that question. So it is so hi, I'm Nitesh. I'm from Microsoft, and my question is around. So you mentioned about foreign companies and they providing certain services of to consumers in India. And even if it's a foreign company, there is a provision under law wherein regulators can go for enforcement. So my question here is, if it's a foreign company not really having a place of business in India, how would be enforceability done? I mean, how are they going to enforce these regulations to a company which is not present in India technically?
I think that's a very good question, and there can be so on the extraterritoriality. I'll just add one more point. The way it can be playing devil's advocate, it can also be argued the fact that you are providing the services within India, right, itself makes it the fact that there is a territorial connection within India. The point that we are trying to make here, the act has to be expressly, saying that there has to be an extraterritoriality where it is missing in the act, and it is tried to be brought into the rules. I thought I'll just clarify that. It is not that the act cannot be extraterritorial. You could have extraterritoriality, but the act doesn't, seem to suggest that there was an intention to be extraterritorial. Now, coming to your point, Nitesh, on the compliance, we completely agree that it is not very clear. And if you see the rules as connected to the act, it is not coming out clearly as to what will amount to enforceability. The only enforceability that we can see here is that they will ask for a discontinuation of the service under section 20, and that also after giving an opportunity of being heard, etc. So a discontinuation of a service. Now whether they will extend to the extent to say that okay, then there will be the ISPs will be asked to block the website, whether it can be going to that level is something we need to examine further. But that could be the maximum way in which from a continuity perspective that could be hampered. But whether you could actually go and prosecute outside India, that will remain a question mark, right? So it is more, enforcement could come more in the way of blocking of the website if at all, and not but the extraterritoriality for criminal law enforcement or otherwise could still be trickier.
Got it. Okay. Thanks.
Thank you.
Thanks a lot.
And probably one more.
We have one
point.
more.
Yeah, go ahead, Jay.
No,
just one.
we have one more question from the audience, but Drew, do you want to come on and ask your question, or would you like me to?
Yeah. So, I mean, I have a very simplistic question, actually. If you look at Section 79 of the IT Act, it says that you act as an intermediary if you do not do three particular things, right? So, as an e-commerce marketplace, under Section 79, if you look at the 1mg judgment, etc., you're not sort of responsible as a result. Does the Consumer Protection Act shift that? These new rules shift that that sort of status of an intermediary, and if so, isn't that contrary to what safe harbor has always been?
So probably I can pick that up, Dhruv and Gauri, feel free to add. It doesn't shift or change anything. So the way the law has kind of laid down the compliances, Dhruv, from an entity localization perspective, let's assume you are a US company and you're a marketplace and you trigger the definitions under these new e-commerce rules. Just by the fact that you're triggering the e-commerce rules, you are made to localize in India, but it doesn't mean that your safe harbor under Section 79, is taken away to the extent you're fulfilling the requirements under Section 79 of the Act. In fact, these rules have differentiated between compliances in an inventory where you're actually the seller, as opposed to a marketplace where you're just acting like a funnel or an intermediary in its literal sense. So when you're a marketplace, for the purposes of these e-commerce rules, your compliance obligations are very different. And the onus to actually validate what is being sold on your platform, or in terms of doing the maker checkers, are not on you, because you're a marketplace in that sense, and you actually are not to be directly liable for what goes on the platform. So they've actually upheld the spirit of the marketplace concept. They've upheld the spirit of intermediary vis-a-vis Section 79 of the IT Act. And in fact, these e-commerce rules actually lay down a provision when it comes to 79 of the IT Act, and says that, to the extent that the marketplace continues to comply with the provisions of the IT Act, specifically Section 79, the safe harbor under the IT Act will continue. So they need to be read harmoniously, not in conflict.
Thank you. That's very helpful.
And Dhruv, if I may be allowed to add one comment, what Hujafa just mentioned, uh, you know, Information Technology Act being a special act will prevail, on the other law as well. So I think the provision of 79 should be prevailed, whatever is given in these consumer rules.
And that's exactly the point that I was trying to make, actually.
I got it, Dhruv.
Thanks.
Yeah, but just one point, guys, Dhruv and Ashish, if you do not comply with the provisions of the CPA consumer e-commerce rules, which are applicable to a marketplace, you cannot seek safe harbor for non-compliance under the e-commerce rules because of 79. So yes, the safe harbor continues, but you cannot shy away from your compliances under these marketplace rules of e-commerce under CPA.
True, Hujafa. Thank you very much.
I have a separate question about who falls under this and who doesn't. The example, because of the low threshold, one of the issues that I think we've raised is there's going to be a lot of smaller companies or organizations that fall under these rules, but they're not even tracking it. And let me just give you an example. I don't know if we have any University of Colorado or University of Chicago alums, but there's a huge number of Indian Americans, for example, that have American degrees. They go onto their college websites. They're buying all kinds of swag and sweatshirts and donating money and so forth to the alumni. Very quickly, universities and many other companies that aren't tracking India at all are going to hit the threshold, right? What happens with all of those sorts of smaller entities that India represents almost notional amount of revenue, or India isn't their primary target, but they're pulling in, I don't know, enough money to hit the threshold, which is pretty low in this instance. How does all of that work for this, not the big boys, but all of these medium-sized companies around the world or institutions that now need to comply with India? They don't even know they need to comply. And if they have to comply, it's certainly not worth the effort, to file taxes for, such a small amount of revenue if they don't already have operations there. What's your general thoughts on how all of this is going to play out?
So I think that's a very valid question, and that is why we have been saying that the threshold has to be identified one way or the other. Today the law doesn't. If you see the PDP bill, slightly digressing, but they have given some definition, at least a systematic activity, right? Whereas here there is not even an identification of what do you mean by systematic activity. So if we just look at the PDP bill as a threshold, what they really mean thereby, if I can just read it quickly, it says that means a structured or organized activity that involves an element of planning, method, continuity and persistence, right? So if you look at that, one random sales that you mentioned, university sale and university sort of selling some insignias and things like that. So that is one off. It is not as if the university is targeting in India in any way. So we probably will need to identify some of those thresholds, and hopefully if the ministry is able to give that guidance, that would be definitely welcome. For example, in some cases the websites actually show an INR amount, right? In which case probably one can conclude that even if it is not a sale occurring immediately, at least there is an intention to carry out that systematic activity. So what could be those indications is something probably the government ideally should clarify. Otherwise, as you said, Jay, there is a possibility that all these people get, are triggering the rules, and it is impossible to, in fact, say that, all these are expected to localize, honestly.
Yeah, and probably one more point which Jay raised, specifically Jay, which I think I briefly mentioned in the applicability, the entire consumer protection law will only get triggered if one, the purchase is for personal consumption. The moment it is used for commercial purposes, the law does not apply. or the second situation where the law does not apply if the digital service or product is given for free. So that is one thing, which I had briefly mentioned in the applicability. I thought of, we should clarify. And joining your point and Gauri's point in terms of the thresholds, unfortunately, the way the law, these rules read, when it talks about systematically and it talks about goods and services, it does not talk about systematic sales of goods and services where you can actually benchmark a number. It just says systematically offering the goods. So the moment you're offering, irrespective of whether the consummation or conclusion of the transaction is happening, it doesn't matter. Just the fact of systematically offering is tipping it over. So extremely well taken in terms of your insights on this, but unfortunately the law doesn't read in that spirit. And we have another question, I think Nakarani, please go ahead.
Yeah, Huzefa, to this point, I have one question. I'm Shailesh Nakrani from Thermo Fisher Scientific. You very well said that for personal, if the goods are sold for personal consumption, they fall under the ambit of consumer protection. And if they are sold for commercial purposes, one is out. But by way of these e-commerce regulations being put up, do you think they widen the ambit where B2B transactions also are covered? Because if you see the definition of user, it says user means any person who accesses or avails any computer resource of an e-commerce entity. So the background here is that we sell our goods to distributors where they place orders online. And there is also a separate website by Thermo Fisher India on which institutions, they come and register themselves, and they buy goods from us and they use it for research purposes or stuff. So for commercial purpose. So do these e-commerce guidelines widen the ambit is my question. Thank you very much.
No, thank you so much, Shailesh. I think if you go to the genesis of these guidelines and where they have been introduced, they have actually been introduced under a particular section of the Consumer Protection Act, which is essentially to prevent unfair trade practices and to protect the rights and interests of a consumer. So this is very important. These rules are meant to protect the interest of the consumer. So to that extent, your business, online selling to another business or online selling for commercial purposes would not get triggered in the sense because you are not selling to a consumer. But at any point in time online, if you're selling to a direct consumer who's not further using it for commercial purposes, yes, the compliances would get triggered.
And I'll add one more element. If we really see, I think you're absolutely right in terms of the way the law has been drafted. But if we really see that, when they talk about the consumer, the inventory-based model, for example, they talk about direct sell to the consumer, right? So they have used the words interchangeably. But if you really see the way I look at it, user need not be necessarily a consumer. What I mean thereby is that if you see the manner in which the user word appears in all these rules, it is what is the information available to the user on the online platform, right? So that means if I'm going to a website, before I buy the product, I need to have access to the information from terms of transparency, right? So to that extent, you can still call yourself as a user because you've yet not availed of the product or a service by making a purchase, right? So to that extent, the user term still works. But when it comes to the actual, but you still need to go back to the genesis of the main act, that if you are not a consumer, product, right, or there is no B2C sale and it's a B2B sale, still the Consumer Protection Act doesn't get triggered. But the word user here is more in the context of the person who visiting the service, which service is actually on a B2C basis. Does that clarify the way they have drafted the rules? Though it could have been done a better job with, but I thought I'll just clarify that position.
Thanks, Gauri. Thanks, Huzefa. This clarifies.
I think we have more questions. So Jay, should we take up the questions or should we?
Why don't we continue on with the conversation and then we'll capture these other questions. I just want to note to Deepa Das on logistics services online, I think when we think of logistics, we're usually thinking of business services. And just to reiterate for the team that these regulations only apply to individuals. So if you were buying logistics companies as a company, it would not apply. Why don't we continue with the conversation, and then we'll capture any remaining questions towards the end.
Sure. I think in the interest of time, we'll kind of summarize some of the points which we wanted to discuss. Now, if we localize, right, now let's look at what is the impact of these regulations specifically from a cross-border trade perspective. And let's take the US-India trade corridor. US e-commerce companies having no nexus in that sense in India, just, there is a website which is there hosted in whichever country and is offering goods. Now look at the ramifications when you need to localize in India. And the simplest way of localizing, as we were discussing before, is to set up a subsidiary, because foreign company registrations is still a bit gray and it's not very common. So the moment you actually set shop in India, you open a subsidiary in India, you have a whole gamut of laws which get triggered. Now, essentially, you don't want to set shop in India for various commercial reasons, but just because you need to comply with these regulations to protect consumer interest, you need to set up shop in India, and everything under the sun which would be applicable to an Indian company, which would get triggered in this case. So I think that is the end-to-end expanse, and that is the end-to-end impact which would happen from an India-US corridor. One, entity localization. The moment you have entity localization, everything gets triggered when it comes to from an Indian regulatory perspective. And second, most importantly, when I say everything gets triggered, even then you trigger the foreign direct investment laws of India. And then, it gets into another different spin, whether you're doing multi-brand retail or if it's single brand retail, or is it a marketplace. And just from a context setting perspective, a marketplace, if your entity localization is happening and if you're a marketplace model of e-commerce, no problem, 100% you can come and set up the company in India. If you're doing multi-brand retail and if you want to set up shop in India because of your digital platform, that is something which is not so easily permissible. It's under the government route with certain regulatory restrictions. And if your online platform, it is just a single any single brand retail trading which is happening online of a US company, and if that's selling into India, again there are various conditionalities which need to be met. So the impact is really interesting depending on what the business model is. Short takeaway is you just need to be careful in terms of how you roll it out. But I think one important point which we definitely should touch base from a cross-border perspective for our audience here is the tax implications which would happen because of the introduction of this law. I think that is also very, very important. And I have my colleague Mayappan, who's an expert of our digital tax team. I think he should definitely give his insights on this. Over to you, Mayappan.
Thanks, Josefa. So I'm just going to quickly touch upon a couple of tax points we need to keep in mind when we are looking at compliance with this new regulation, right? So considering that the localization would be most likely maybe in the form of an Indian entity, the first issue that comes up straight away is transfer pricing on the activities that are being conducted by the Indian entity. So that's something that will have to be done. The second issue that can come up is if the localization is in the form of a LO or a BO, we could also be looking at permanent establishment issues depending on the activities being carried out. But that's something that we just need to be cognizant about and make sure that the PE thresholds are not triggered through any of the activities that are being carried out here. The third thing that could also come up is from a GST perspective, there are certain activities such as the grievance redressal. Right now, previously under the service tax regime, there were some clear rulings which said that a local entity providing a service to a foreign entity, even if it meant interacting with its customers in India, would not be intermediary service, but would be an export of services like a call center or payment support service. Even if it means interacting with the local customers, would not be a taxable service. But recent AAR rulings have been overturning that position. So that's something that could potentially apply on some of the services being done by the Indian entity, where a GST of 18% could be applicable. Couple of other provisions that companies also need to keep in mind, and this may not necessarily be tied to the localization requirement, but from running a platform is the 194O withholding requirement that was recently introduced. This is a 1% withholding requirement on an e-commerce platform, or the person who manages, owns, or operates an e-commerce platform. And when the payment is being made by the platform directly to the seller, a 1% of the amount has to be deducted as TDS. There is an explanation which also deems that even if the money is not really handled by the platform, that would also be covered within that section, and there is an obligation to withhold. But I think there are arguments. It's a pretty badly worded section, and on different business models it can, and there are good arguments to say it doesn't apply. But importantly, I think the way to read the explanation is that it should ideally apply only in situations where the platform facilitates the payment, maybe through a payment portal. But if it has nothing to do with the payment and it's completely done between the seller and the buyer through cash in some certain circumstances, then I don't think the platform should be covered. So these are the broad issues that I think from a tax perspective, we need to keep in the back of our mind.
Thanks, Mayappan. I think, Jay, we have another question from Deepa. We can probably answer that. And I can, Deepa, you want to?
Please, go ahead.
Yeah, I think Deepa's question is, would selling of courier services online to the customer fall within the ambit of these rules? Yes, it would. So let's pan it out. If you are a foreign company and offering courier services to Indian consumers, and if you're systematically offering these services, it would fall under the ambit of the rules. The reason is twofold. One is the systematically offering goods or services, and second is the definition of service is very wide under the Indian Consumer Protection Act. It essentially means everything and anything under the sun.
Yeah, I'll just add, however, one, counter argument, and we need to see how it can be argued, and this may apply to several other services as well. Whether we can say that there is no e-commerce here because the service is not being provided over the digital or electronic network. The service of courier service is a physical activity that is being carried out. What is happening through the, is merely a coordination. So that is one argument, but the definition of, e-commerce is very wide, but we could explore this further, if we want to really argue it out to say that when you say over digital network, that means the entire service offering, has to be over the digital network and not simplicity or a coordination. For example, if there is an emails, through email, if there is a coordination happening, does it mean that that emails coordination itself amounts to e-commerce, right? So that we could try to explore some of these arguments as well. It's a fairly new law. We need to see how the courts look at it, but I thought I'll give another argument also, on this particular point.
Thank you. Sorry, go ahead, Deepa.
Thanks, Jay. So this is very helpful. Actually, we will have both Gauri and Zefa. We'll have both the situation. We are FedEx, and we provide you service where you can go online, pay through your credit card, and we come and physically pick up the shipment and go and deliver. So that's the service. And there is a second scenario which you already said, that the schedule, you schedule a pickup and you actually don't pay anything online, and we come and collect the cash and pick up the service, pick up the package. So both are there. So yes, this is a troublesome area in terms of there the wide ambit of the act comes into play. And so my question was also, in your experience during this phase from the date of notification till now, are these rules being challenged anywhere from the virus perspective, or extraterritorial approach, long arm jurisdiction, and things like that, which you have been discussing? Thank you.
So yes, there has been
helpful and good information.
Yeah. So I think we have been definitely deliberating about it. In fact, we have been speaking also with some of the relevant government departments about clarification of some of these elements, but we have not yet seen a challenge being actually being filed, at least not to our knowledge. But yes, there have been such discussion, and it may also depend upon how aggressively does the consumer affairs department actually goes to enforce these laws, right? And I believe there is, if you really see, if you try to tally between the rules and the act, there isn't really that strong mechanism available today for direct enforcement, right? It's a roundabout enforcement mechanism by first trying to do certain activities to the consumer council, etc., right? But there is this definite clarity required, and I believe at least we have sent representations. I mean, we were sending representations even when the rules were in the draft form to clarify some of these positions, but there is a strong need to do that. And otherwise, when they suddenly you start receiving notices, what we saw in the country of origin issue under the Legal Metrology Act, suddenly it was picked up. It should not happen that the law is again used for similar purposes last minute, if people are not aware of the compliances.
I think, yes, thanks. I think that this is excellent. Thank you.
And just, I think
Thank you.
one more point, sorry to just kind of stretch this a bit, but I think Deepa gave a fantastic example, right? In the traditional brick and mortar world, you will go to a physical outlet of, say, FedEx, and pay the money and get the service. When it comes to the digital world, you're completely removing the physical element, whereby sitting at home, you book a courier, the courier probably comes, or you give it to someone, and it kind of moves forward. I think the key being, Deepa, is how would you read selling of goods vis-a-vis the digital or electronic network? I think that the linkage between the two would be very critical from an interpretation perspective.
Thank you. I agree with you. But more we are looking at it, it appears we are falling within the ambit, some aspect of it, even if it is a very limited aspect of the business. Because as you said, no consumer definition, you have to see it as to be the consumer, and
It has to be consumer driven and consumer friendly, correct?
I think what we note here, just as a takeaway also, what we note here is, unfortunately, if you see the rules, they have tried to just, straitjacket you into some, one method or the other. But today there are multiple models of e-commerce, and if you simply focus on what is it that is required is the consumer transparency and grievance redressal, right? So if that is the focus, do you really need, such rules for each business models? In my mind, they should simply articulate what is to be achieved and then leave it for all the stakeholders. For example, between marketplace, the stakeholders will be different. In your type of businesses, the stakeholders are different. So how do you achieve that end goal? If something should be left to the businesses, what they have tried to do is to micromanage, right? So I think that is where the difficulty comes in, in overall compliances and the impact of that.
so Gauri, you yourself mentioned PDP Act. So we Jay is leading that as well. So the idea is to say that self-regulation. So the government was moving about 2 years back towards self-regulation model. Now they're again have come back to over-regulation. That's the problem in every area. The thing is that they are trying to do something which will just disrupt the whole marketplace, and really the objective they want to achieve, how much they'll be able to achieve, one doesn't know, but one would be trying to grapple to ensure compliances around that. So they're just disrupting the whole marketplace, and it's not just the consumer phase. Every area you pick up, they want to do regulation model. They don't want to have the self governance model, what you just rightly said. So one has to find ways to make that take that noise to the government. How do we take that? That's a bigger challenge today.
Yeah.
So what I've done is I've just pasted one article that I had written exactly on this point. So maybe the participants just can pick it up from the chat box, and you could probably look at that article where I've brought up all these points. Yeah, Jay.
Thanks.
Yeah, thank you. How do we deal with digital products and services, right? When you're talking about an inventory-based model, you're basically holding some sort of inventory. In the digital realm, you don't really have that same traditional inventory. And as a sort of a follow-up question, how do you deal with, or how might the laws deal with things like streaming services or gaming or other sorts of esports that might have a primary product, but also they might be a secondary market? You know, there's all kinds of tertiary products on Angry Birds, or if you want to go Pokemon Go, just as a couple of examples, right?
Yeah.
And you have communities. So you have a source Pokemon, but then you have all other kind of, which might suggest some sort of inventory model. But then you have all kinds of third-party add-ons, which would suggest a marketplace model. And then, of course, lastly, you have this whole payments piece, right, which is clearly not inventory, but over electronic. How are these digital services, you know, what's your best guess of how this starts to fit into this regime?
Sure. So let me just take that because we have examined, especially because I do a lot of work on the gaming space as well. So I'll just explain how we are looking at this, and happy to sort of see what members have to say. I think what we really are focusing here is the definition of e-commerce, where we are talking about buying or selling, right? So therefore, the focus has to be, when you say digital product, is there a sale happening of a digital product? For example, I'm downloading a music file versus I'm taking a streaming service for the music, right? So if I'm downloading, I'm actually taking a delivery or the ownership of a digital product, which otherwise I would have probably taken via DVD as the ownership. So that is one way to look at it. And where I'm not having that ownership, then it can remain in the service. And there is some guidance even under the GST law on these lines. And the reason we say that, somewhere in the gaming field that you mentioned, there are 2-3 models that we see, right? And if we see the terms and conditions internationally also, what they say is that, you know, the skins that you buy, or, you know, some of the virtual coins that you buy or whatever, at least the most of the terms and conditions state that there is, this amounts to a license, and you can't use these products outside the game. So there is no independent value for those skins, or, you know, digital coins or stars or hearts or whatever outside the system, right? And therefore it still remains as a license, which is service, for me to continue to use the product in a particular way. And it is therefore not a digital good for which there is a inventory or a buy and sale happening. This is a very nuanced argument. We'll need to examine how the courts look at it, but that is the way we were looking at it. And especially because we do have some comfort coming under the GST law as well. And even, you know, taking the argument slightly, stretching it further, if you see the definition of e-commerce also under this act as well as the FDI policy, the word digital products is coming after the word service, because it says service including digital product, right? So whether we can say that the digital product are being used in the context of service in that sense, or do they have to be viewed as an independent thing, right? So, I mean, then there is a definition of the term product, definition of the term good. So there are quite a few nuanced legal arguments, but to simplify, something I'm not taking ownership of, but I'm simply getting access to, I could argue that as a service.
So would that mean that those types of digital products would be covered under the marketplace model, or not covered at all? And under
it would be
regulation?
Yeah. So those would be, I mean, honestly, for the service, honestly, I don't first of all understand what you mean by inventory of a service, unless you are taking somebody else's service in your books as a commitment, you know, and then passing it over. But if it's your own service, I mean,
well, you're buying a license, right?
Yeah,
so,
yeah.
And then you
So
have,
I'm
and then
doing
you're holding that license.
Yeah. So I think there is still could be a inventory based, but for the service, not marketplace. Yeah.
Okay. So what I'm hearing is there's some, it's not super clear. There'll be some discussions, some clarifications. There'll likely be some case laws as we get deeper into this regulatory model or regime. There's going to be a lot of open questions that still need answers, if I'm hearing you correctly.
That's right.
That's correct.
And I presume our members could reach out to you with very specific questions as a follow-up, right?
No, absolutely. And we have examined in various scheme of things, we have examined several models. And, there are multiple laws. You have, apart from this law, you have, the tax law, you have the payment law that you mentioned. So all these, multiple laws have to be seen together, especially in the case of cross-border payments, etc. So you will have to look at the entire ecosystem to finalize the business model, honestly.
Thank you. Husefa, back to you to continue the conversation.
No, I think we are spot on time. I think it's already an hour and 5 minutes. What we could
Let
do
me
here,
ask
yeah.
one final question for the three of you, right? So this is a new regime, right? We're trying to figure out where we're going. And can the three of you each sort of provide a little bit about where we're going from here? What's next? What steps can we take? What is the government doing? Where you think this is all going?
So probably one thing which, I think Gauri also spoke on that, right, Jay, is that there has been some sort of an advocacy post these rules have come. We have been involved with some Chamber of Commerces and given our feedback. In fact, Gauri personally also has given feedback to the ministry. And what we are hoping for, Jay, is in the next few months, the larger players in the market, the larger online players, and some of them are actually from the US itself, would approach the government in some manner to get some sort of clarity in terms of an implementation perspective, because if they need to implement it as it is, it kind of rejigs the entire business model for them. So one thing is approaching the government for some sort of clarity. That could be one option. The second, which could actually be triggered by if there is some sort of a consumer complaint in India, whereby the authorities are compelled to take some action. That itself will also be very interesting if somebody is actually pulled up, and the response to that sort of an investigation by the e-commerce company would also lay some jurisprudence, and if that gets litigated, even better. And I think the third outer risk is a public interest litigation, which could be filed in terms of implementations of these rules by the companies, and if they've not been doing it. So there are various avenues. Probably in the next few months, we see some sort of pathway, some sort of clarity, whether by choice or not by choice, but hopefully that should come. I don't, Gauri, if you want to add, please.
Yeah, I somehow feel that, some amount of advocacy should continue, because there are several gray areas in the rules and the manner in which they have been drafted, especially different business models require different sensibilities. So I believe, I feel that the industry should still continue in some amount of advocacy for, for getting either a clarification or update on the rules, and give it, and the advocacy has to be with specific examples to demonstrate that how the rules fail, in certain business models, and request the government that let us focus on transparency and consumer redressal, and then let the industry, really take care of that, and then that should, satisfy the government rather than micromanaging, as I have said before. I believe that we should definitely continue that effort, because what we saw in the Legal Metrology Act, the rules came in of the country of origin disclosure several years back. Absolutely nothing was done, and one fine day, the entire industry had to churn out, their product. They had to revamp the product, right? So a lot of energy goes in building the product, the platforms and everything. It is important that businesses have clarity in terms of, the actual compliances.
Great. One final question. What are you hearing in terms of next steps of either new regulations, new orders, new guidelines? And are you hearing anything specifically about the ramp up of the Consumer Affairs Commission itself, the new regulatory body? Any insights just sort of going forward? Where is this regime going in the next, let's say, 3 to 6 months?
So, Jay, if you really see, the activity has continued. If you see, there is another rule that came in couple of, weeks back on the misleading advertising, right? So there are several rules that will keep coming in, from the ministry. And we now have a new minister, as you're aware, as well. So maybe he will have a fresh perspective to the game. for us to examine, how do we take it forward. But the activity has started, the council has been established, so the activity has started, but the speed, etc., will also depend upon several other, moving pieces. But we see definitely that there is an intent to address some of these issues. And that's why you're seeing so many rules being, taken out from the ministry.
Yeah,
Great, thank you.
Yeah, and I think one thing which hopefully should expedite this entire process, the implementation of this new act. The reason why it took time is that at an execution level, they still did not have the relevant agencies at a district and further sub-district. I think that was one of the roadblockers in the past for a successful implementation. Hopefully, in this new law, at an execution level, they've gone more granular. Which would actually increase the expanse of the regulatory arm. So that's another thing which may happen and expedite, compliances.
Wonderful. Thank you. I want to see if our members have any final questions for our really expert team here. Going once. Okay. I really want to thank Maya, Gauri, and Josefa for this. Was a fascinating conversation. This is an area we've been tracking and didn't really understand well. So I want to thank you and all your team for providing us just a greater understanding. I will open the door if any of our members want to reach out to the NDA team. We'd be happy to connect them. I want to thank NDA for all your great work with USIBC. Last week, beyond this event, the last week on Thursday, you guys moderated a really great 5G conversation. We released a report as part of our digital week. And so we're really thanking you to join us today to join our extended digital week as we sort of lean forward on the US-India strategic digital partnership. So with that, I wish our members in both the United States and in India, everybody please stay safe in these difficult times. And thank you, and don't hesitate to ever reach out to us where we can support your efforts.
Okay, thank you.
And
Jai, we will send you some of the points that we have communicated for your information, so you have them with you as well.
Excellent.
Great, and we can share that with our participants.
Sure.
Yes. Thanks, Jay, for hosting this. Thank you.
Thank you.
Thank you very much. Thank you, guys.
Bye-bye.
Thank you so much. Bye-bye.
Bye-bye.